685 do pass by substitute, Semi-Sir Kirk of the 13th. And Mr. President, Senate State and Local Government Operations Committee has had under consideration the following legislation. Instructed me to report the same back to Senate for following recommendation. House Bill 121 do pass by substitute. House Bill 460 do pass. House Bill 534 do pass. House Bill 611 do pass. House Bill 623 do pass. House Bill 635 do pass. House Bill 639 do pass. House Bill 642 do pass. House Bill 637 do pass. House Bill 644 do pass. House Bill 645 do pass. House Bill 646 do pass. House Bill 647 do pass. House Bill 648 do pass. House Bill 649 do pass. House Bill 650 do pass. House Bill 651 do pass. House Bill 653 do pass. House Bill 654 do pass. House Bill 656 do pass. House Bill 657 do pass. House Bill 681 do pass. House Bill 682 do pass. House Bill 683 do pass. House Bill 688 do pass. House Bill 689 do pass. House Bill 694 do pass. House Bill 695 do pass by substitute. House Bill 696 do pass. House Bill 697 do pass. House Bill 698 do pass. House Bill 678 do pass. And House Bill 668 to pass. Submitted by Senator Kirk of the 13th. Mr. President, that concludes the order.
Mr. Secretary, will you read bills for a second time?
House Bill 665 and House Bill 685. Mr. President, that concludes the order.
This time we're going to go back onto the rules calendar. Mr. Secretary, will you read the caption to House Bill 290?
House Bill 290 by Representative Cooper of the 43rd and others. A bill be titled and acted in Chapter 17A of Title 31 of the OCGA relating to control of HIV, so as to establish a pilot program to provide pre-exposure prophylaxis, drug assistance, or services to persons at risk of being infected with HIV and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 32nd to speak to House Bill 290.
Thank you, Mr. President. House Bill 290 is a public health bill. It relates to the HIV epidemic that I talked about earlier this week has become much worse due to our drug crisis, and this bill is another potential solution to our problem of being one of the worst states in the country for new cases. The bill would create a 3-year pilot program for a preventive medication called PrEP in a few of our most highly affected counties identified by the CDC. The Department of Public Health would develop guidelines and report back on the results. The program would include screening, education, referrals for drug treatment, and other wraparound services. And anticipating a question from the senator from the 48th, I do have a fiscal note. The cost for the first year would be $50,000 with a total of $300,000 over 3 years, subject to appropriations. The department could also solicit grants. This bill is another approach to address the massive problem in our state that tracks our drug epidemic, and I ask for your favorable considerations. If there are no questions, I yield the well.
You have no questions.
Thank you.
We might start to refer to those as District 48 forms. Does any other senator wish to speak for or against the bill? Chair hears none, and the previous questions ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 52, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, will you read the caption to House Resolution 37?
House Resolution 37, a resolution creating the Georgia Commission on Freight and Logistics and for other purposes by Representative Tanner of the 9th and others. Mr. President, Senate Committee of the Senate on Transportation recommends that this resolution do pass, submitted by Senator Beach of the 21st. Mr. President, that concludes the order.
Chair recognizes the senator from the 21st to speak to House Resolution 37.
Thank you, Mr. President. Colleagues, I bring before the Senate, I bring before House Resolution 37.
That's out of order.
I bring before you House Resolution 37. It's the exact same language as Senate Resolution 19 to create a commission on freight and logistics to look at freight and logistics throughout the state of Georgia. One of the things we've done, our port has grown and at a rate of about 60% last year, and we need to look at moving freight through our state and getting goods and services from point A to point B in an efficient manner, and that's what this will do. And this commission will be created, and then it'll disband by December 31st of 2019. I'd ask for your support. If there's no questions, I yield the well.
You have no questions.
Thank you.
Does any other senator wish to speak for or against the resolution? The chair hears none, and the previous questions ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage to the adoption of the resolution? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this resolution now be adopted? The question is on the adoption of the resolution. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the adoption of the resolution, the yeas are 51, the nays are 1. This resolution, having received the requisite constitutional majority, is therefore adopted. Mr. Secretary, will you read the caption of House Bill 296?
House Bill 296 by Representative Hawkins of the 27th and others. The bill will be titled and amending Code Section 15-6-3 of the OCGA relating to terms of Superior Court so as to revise the term of court for the Superior Court of Hall County in the Northeastern Circuit and for other purposes. Mr. President, that concludes the order.
Has anyone seen the senator from the 49th, our pro tem? I was just with him a second ago. The chair would like to recognize the senator from the 49th to speak to House Bill 296.
Thank you, I got it. This is a change to the term of court in Superior Court in Hall County to make it more available for versus the vacation seasons. I'm not sure if the vacations are for the judge or the jury. If there are no questions, I yield the well.
You have no questions.
Thanks, sir.
Any other senator wish to speak for or against the bill? The chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass? The question is on the passage of the bill. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. State your inquiry.
Thank you, Mr. President. Would it be too much to ask for the secretary to print a list of the bills in the order that we're going to take them up so the sponsors could be aware and be in the room?
The chair believes that's already been done. Chair recognizes the senator from the 49th.
Parliamentary inquiry,
State your
Mr. President.
inquiry.
Isn't it true the senator from the 31st? That's kind of funny, Bill.
That's not very nice. On the passage of the bill, the yeas are 53, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Well done, Senator. Well done. Mr. Secretary, will you read the caption of House Bill 307, please?
House Bill 307 by Representative Powell of the 32nd and others. The bill will be titled an act to amend Chapter 10 of Title 15 of the OCGA relating to magistrate courts so to provide for jurisdiction of such courts to provide for filing certain documents electronically and for other purposes. Mr. President, the Senate Committee on Judiciary offers the following substitute to House Bill 307. A bill will be titled an act to amend Chapter 10 of Title 15 of the OCGA relating to magistrate courts so to provide for jurisdiction of such courts to amend Chapter 3 and Chapter 11 Title 40 of the OCGA relating to certificates of title, security interest, and liens in abandoned motor vehicles, respectively, so as to provide for issuance of a salvage certificate of title under certain conditions and for other purposes. Amendment 1 by Senator Stone of the 23rd and others offers the following amendment. Amend the Senate Committee on Judiciary substitute to House Bill 307 by deleting line 358 and inserting in lieu thereof the following: specified pursuant to an agreement with a local governing authority except when otherwise exempted or provided for by federal law, rule, or regulation. Mr. President, that concludes the order.
Chair recognizes the senator from the 23rd to speak to House Bill 307.
Thank you, Mr. President. Senators, House Bill 307 is the Abandoned Motor Vehicle Act. This deals with the problem of abandoned vehicles around the state, along roads, on public and private property, in shops and junkyards, wherever they're found. It's primarily aimed at the towers and storage providers, salvage dealers, and repair shops, but it impacts magistrate courts, Department of Revenue, credit unions, DOT, Department of Public Safety, Sheriff's Association, GBI, and the insurance industry. So it's had a lot of input from different stakeholders. It streamlines and brings due process to the disposition of abandoned motor vehicles. It's patterned after a bill that we passed during a recent session that dealt with abandoned mobile homes, also a problem in Georgia. It accomplishes the clear direction that the industry needs by ascertaining when vehicles can and should be removed, how the owner should be ascertained, whether it's stolen or not, determined. It also authorizes the tow and storage and what circumstances that can happen. It directs the form and manner of notice to the vehicle owner. The form of notification is patterned significantly along the lines of notifications dealing with bad check law. Certified letter, return receipt requested, overnight statutory mail, and where the owner cannot be ascertained, legal advertising. It provides time to retrieve personal items from vehicles, authorizes a lien. It sets limits on the claims against the vehicle, provides jurisdiction in magistrate court to adjudicate the claims, just like we do abandoned mobile homes. It provides for notice and a right for a hearing, an expedited process. It empowers the court to order a public auction, provides for notice of sale, and authorizes deduction of allowed fees. Then it provides for turnover of excess proceeds to the Department of Revenue Unclaimed Property Division. Allows 2 6-month periods for claimants to assert claims against the fund. There is an amendment that we've offered that provides recognition to the situation if there are any federal rules governing tariffs dealing with towing off of federal interstates and U.S. highways, that would preempt the state rules regarding tariffs. With that, I'll yield to questions, if there are any.
You have no questions.
I urge support and adoption of HB 307.
Does any other senator wish to rise and speak to either amendment number 1 or to the measure? The chair hears none. We will take up amendment number 1. The question is on the adoption of amendment number 1. Is there objection to the adoption of the amendment? The chair hears none, and the floor amendment is adopted. The question now is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Chair hears none. The committee substitute is adopted as amended. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none, and the main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 48, the nays are 3. This bill having received the requisite constitutional majority is therefore passed by substitute. Mr. Secretary, can you please read the caption of House Bill 319?
House Bill 319 by Representative Williams of the 148th and others, a bill entitled an act to amend Article 6 of Chapter 7, Title 47 of the OCGA relating to retirement, retirement allowances, disability benefits, and death benefits relative to the Georgia Firefighters Pension Fund so as to provide that a member's benefits payable after death shall be paid to his or her estate when such member failed to designate a beneficiary and for other purposes. Mr. President, that concludes the order.
Chair recognizes a senator from the 52nd to speak to House Bill 319.
Thank you, Mr. President. This is a firefighter's bill, and with apologies to the firefighter caucus, the senators from the 53rd and the 56th, this representative was new and didn't know that to give it to the caucus members, so he gave it to me. Anyway, what this does is there's only 4 lines on the back page that changes, and that says that if you are in this pension fund and you're deceased, that if you don't name a beneficiary through negligence, ignorance, whatever, or if your beneficiary has deceased ahead of you, then rather than it staying in the fund, that it would go to that person's estate. And if there's no questions, I'll yield the well.
You have questions. Chair recognizes the senator from the 53rd for a question.
Thank you, Mr. President. Senator Yield.
I'll yield to the rules chairman anytime, especially on a firefighter bill.
Indeed, and isn't it true that the senator from the 56 and myself, who are firefighters or have been, in my case, appreciate your work in helping the brother and sister and firefighter? It'd be yes.
And I do agree that, but I'm really more interested in helping your estate than you in this.
And
bill.
thank you for that. And isn't it true, would you further yield?
I'll yield.
Isn't it true, it would really please the senator from the 56 and myself if you could state the firefighter motto? Thank you, Mr. President.
I don't know that motto, but I know you find them hot, but past that, I'm not sure.
Chair recognizes the senator from the 46th for a question.
Thank you, Mr. President. Will the senator yield?
I'll yield.
I seem to remember this bill passing a few years ago, and the idea was, as a state, we wanted to make certain that if any of our firefighters died in the course of duty, et cetera, that we would provide for their surviving spouse and children. This troubles me because now we're leaving it to their estate, and that doesn't accomplish that purpose. There could be somebody with no heirs or dependents whatsoever that we're still paying the money out of state funds, out of all our taxpayer funds, that don't accomplish the original goal of the bill.
Well, this was brought by the firefighters pension group, and they said the current problem is that it was staying in the fund and not going to their estate, and they were trying to have a mechanism to make sure it did go to their estate.
Will the senator further yield?
I'll yield.
Well, wouldn't that be to the benefit of other beneficiaries of firefighters to leave money in the fund so that if any of them die that do have dependents that are surviving them, that we'll have adequate funding for them?
I'm sure that could be an argument, but I do think that was earned by that individual, and that their estate and the subsequent beneficiaries of it should get the funds.
Chair recognizes the senator from the 56th for a question.
Thank you, Mr. President. Will the senator yield?
I'll yield with apologies for carrying the firefighters bill instead of the caucus.
Senator, isn't it true that this is very important if a firefighter who died in the line of duty did not have a will, and they may have been taking care of a family member, maybe someone with special needs or an aging parent, that this could make all the difference in those dollars going to their estate and taking care of their family?
I'm sure the senators from the firefighters caucus knows of which he speaks.
Thank you, Senator.
You have no more questions, Senator.
And I'm proud of that.
Does any other senator wish to speak for or against the bill? The chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? Chair hears none. The main question is ordered. Shall this bill now pass? The questions on the passage of the bill. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. For what purpose does the senator from the 8th rise? He waves. I wonder if the senator from the 7th had anything to do with that. For what purpose does the senator from the 48th rise? On the passage of the bill, the yeas are 53, the nays are 0. This bill having received the requisite constitutional majority are therefore passed. Ms. Secretary, can you please read the caption of House Bill 349?
House Bill 349 by Representatives Martin, the 49th, and others. A bill will be titled and enacted in Code Section 36-44-3 of the OCGA, relating to definitions regarding redevelopment powers so as to authorize counties to exercise powers and incorporated areas and for other purposes. Mr. President, that concludes the order.
Before I recognize the senator from the 14th, I want to let everyone know we've got dinner boxes in the ante room for y'all to be able to grab. So those are available now for y'all to get if anybody's hungry. Chair would like to recognize the senator from the 14th to speak to House Bill 349.
Thank you, Mr. President. First, this bill is not from the Pentagon, to start with. The Georgia Constitution allows cities and counties to exercise redevelopment powers if authorized by a local act and confirmed by the voters in a referendum. The effect of HB 349 is to conform that counties with redevelopment powers may create TADs within the constitutional boundaries of the county and pledge county property taxes levied for the county governmental purposes if some or all of the TAD lies within a city. Very simple, one-page bill. There's no need for a fiscal note on this, and I'll yield well and ask for your favorable consideration.
Senator has yielded the well. Does any other senator wish to speak for or against the bill? The chair hears none, and the previous questions ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? Chair hears none. The main question is ordered. Shall this bill now pass? The questions on the passage of the bill. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 51, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Ms. Secretary, will you read the caption of House Bill 379?
House Bill 379 by Representatives Moore of the 95th and others, a bill be titled enactment Part 1 of Article 3 of Chapter 8 of Title 40 of the OCGA relating to county special purpose local option sales tax so as to revise the annual reporting requirements regarding projects and purposes using SPLOST funds and for other purposes. Amendment 1 by Senator Orrock of the 36th and others offers the following amendment. Amend House Bill 379 by replacing lines 1 through 3 with the following to amend Chapter 8 of Title 48 of the OCGA relating to sales and use tax so as to revise the annual reporting requirements regarding projects and purposes using SPLOST funds to redefine the term municipality and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 48th to speak to House Bill 379.
Thank you, Mr. President. I rise today to bring you House Bill 379, which is a bipartisan effort from the House. It provides flexibility to local governments with respect to publishing a yearly SPLOST report in the local newspaper. Currently, local governments have to publish the report by December 31st. House Bill 379 would instead focus the reporting date to be based on the fiscal years of those governments. Right now, there are currently 326 local governments who have a fiscal year ending on December 31st, 268 who have fiscal years ending in June 30th, and 58 local governments who have a fiscal year ending on September 30th. The statute would be changed to provide 180 days from the end of the fiscal year for local governments to publish their reports. So this would give all the local governments, even those with December 31st fiscal years, the same amount of time to complete their reporting. I'm happy to answer any questions, or I'll yield the well.
Chair recognizes the senator from the 14th for a question.
Senator Yield,
Yes, sir.
is there a fiscal note?
Thank you for that great question, Senator. As you know, I am very, very concerned about fiscal responsibility and spending, and it is my understanding that there is no fiscal impact of this bill, but I do appreciate your concern.
Further yield.
Yes, sir?
Is it not true that Atlanta, East Point, College Park, and Hateville share the same sewer system? And all this bill is doing is allowing the cities surrounding Atlanta the same process to vote by referendum?
I cannot speak to the amendment on this bill. I am speaking as to the bill.
Okay. Thank you.
Chair recognizes the senator from the 18th. Senator, do you yield the well? You have a question.
Oh, I'm sorry. I thought you.
Chair recognizes
sure.
the senator from the 18th.
Yes, sir.
Does the senator yield?
Yes, sir.
Have you gotten a fiscal note on this bill, Senator?
Thank you, sir. Did you hear Senator Thompson's colloquy with me?
Senators will be referred to by their districts.
Oh, I'm sorry. Did I say the senator from the 14th? I apologize. Did you hear that colloquy, sir?
Well, I heard a little bit of it, Senator, but I wasn't quite clear. I wanted to make sure that whatever fiscal impact we have from this bill, we certainly discuss it.
Thank you, sir, and I appreciate that you, like me, and the senator from the 14th are all concerned about fiscal responsibility, and I'm happy to report that is my understanding there is no fiscal impact here at all.
And do we have, Senator, yield for one final?
Sure.
Do we have a fiscal note saying that there's not a fiscal impact?
I do not, but I have been told that by all the representative mayors who have requested this, as well as the different organizations who have worked on this bill, because I did ask that question.
Very good. Thank you, Senator.
Thank you, sir, and I appreciate your continued concern for the fiscal responsibility of our state.
Do you continue to yield?
I yield the well.
The senator has yielded the well. Any other senators wish to speak for or against the bill? Chair recognizes the senator from the 36th to speak to her amendment. Amendment number 1.
Thank you, Mr. President. Colleagues, I will briefly present the amendment. I am rising in support of HB 345, which is a good streamlining, efficient government bill that the author has carefully shepherded through the process. The amendment that I am offering for your consideration is an amendment that would impact small towns that several of us represent south of Atlanta in the airport vicinity, College Park, East Point, and Hateville. And they are impacted by the fact that Atlanta has a most tax, that's municipal option, special tax to do infrastructure repair, renovation, and modernization of our water and sewer system. That has been underway for some years and is very successful. The language in the amendment would allow these smaller cities that are part of the water, using Atlanta's water, buying water from Atlanta, that they can modernize and have a way to vote themselves a most tax if they choose in order to modernize their water hookups to the Atlanta system. It's very simple. It's high stakes for the citizens and the government of those three small cities. I'd urge your support. Thank you. To no questions, I'll yield.
You have questions.
Thank you.
Chair recognizes the senator from the 19th for a question.
Thank you, Mr. President. Senator Yield.
I yield.
Senator, honest question about your amendment. If I understand correctly, these smaller cities, you're trying to take the tax off where they do not have to pay the most tax for these larger places?
No, that currently, in order to invest in their water and sewer infrastructure, they are using general funds because they don't have, until we enable them with this legislation, the most tax. They don't have the ability to offer that referendum option to their voters. This would put it on a referendum that they would be able to vote up or down whether they want to put a penny on their infrastructure repair. And that would help them catch up with the Atlanta situation that's modernizing all around them and from whom they get water. So it's a very important economic development possibility for the
Thank you
city.
for your clarification.
Thank you. If there are no other questions,
You
I'll
have more
yield.
questions.
All right.
Chair recognizes the senator from the 8th for a question.
The lady yield.
I gladly yield to the gentleman from the 8th.
Is it not true that the most tax was put on originally to address a unique problem that the Atlanta had with the federal government, and some actions been taken? Is there any connection between allowing these counties,
Between the what?
these additional cities, to impose this tax, and the
Could you-
relationship with the problem that this was originally designed for?
No, these municipalities are not under any kind of court order, such
that's
as
my
was
understanding.
impacting the Atlanta system when we were experiencing the bad sewage overruns and the contamination of water. You know, we're paying fines. They don't want to get to that point. They want to put in their penny, let their voters vote for it, so that they can avoid that.
Is this not just a further expansion of the most tax without the cause that was used to implement it for the city of Atlanta?
That's right. It would be other voters in these other cities that are
And
included.
another tax increase.
It's strictly up to the voters. They can vote it down. They absolutely are. The power is in their hands if we so deem with this amendment. Thank you so much. Appreciate your support. It's a very important measure that we can do for these small cities around the airport. I yield the well.
The senator has yielded the well. Chair recognizes the senator from the 56th to speak to the bill or the amendment.
Thank you, Mr. President. I want to commend my friend for 36 of this important issue. However, I do fear that it has unintended consequences to other cities that have these interconnects. And while I think the issue that you're bringing up may be very valid and important, I do fear that it opens up more than we probably want to do at this point, especially knowing other cities will be impacted by that, as well as the comments by the senator from the 8th. So I'm going to ask you to vote this down and work on this offline so we can make sure it's only tailored to the area that needs it. Thank you.
Senator has yielded the well. For what purpose does senator from the 45th rise? She waves. All right, we're going to take up amendment number 1. What purpose does senator from the 36th rise?
Thank you, Mr. President. Isn't it true, I'd like to clarify that the descriptor in the language of the amendment limits it to these 3 municipalities. It is not opening anything up because other cities don't meet this definition.
That's for each and every member to decide on their own.
Thank you.
For what purpose does the senator from the 45th rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that the people in the well left the well? And I think the underlying issue is we want to know if this is a tax increase, if those municipalities that are included, could they raise other taxes? That was what the underlying issue is, I believe.
I would encourage you to continue to work with other members to derive your answer. Chair recognized. For what purpose does senator from the 8th rise?
Thank you, Mr. President. Parliamentary inquiry.
State your inquiry.
Is it not true if this amendment were added on and this bill was passed, this would open up the door for every city in the state to want to implement a most tax?
Each and every member will have to make that decision. For what purpose does senator from the 48th rise?
Parliamentary inquiry.
State your inquiry.
May I close out the?
We've closed debate. We're
all right,
moving
may I
on.
make a parliamentary inquiry?
State your inquiry.
Or actually, I should say, point of order.
Point of order. State your order.
I would like to state that the original bill, House Bill 379, is a carefully worked out bill that was handled by one of the main sponsors in the House, and that sponsor has asked that this bill pass without amendment, and I leave it to each and every senator to decide on their own.
For what purpose does senator from the 36th rise?
Parliamentary inquiry.
State your
Mr. President.
inquiry.
Yeah, isn't it true that to allay any fears that any other taxes, this is the most
State your
taxed.
inquiry.
Is it not the case that the language on lines 14 through 16 specifically limit this to
Senator,
three
we're going to take up
cities?
the amendment. Thank you.
Thank you.
We'll take up the amendment. Amendment number 1, the question is on the adoption of amendment number 1. Is there objection to the adoption of the amendment? There is objection. All those in favor of the amendment from the senator from the 36th will vote yea. Opposed, nay. The secretary will unlock the machine. On the adoption of the amendment, the yeas are 18, the nays are 36, and the amendment is lost. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass? The questions on the passage of the bill. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 52, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. I'd like you all to join me in thanking Patrick Mathis for being the only page that's still with us on this young after evening. I also want us as a body to recognize the fact that we are the only chamber still working hard for 11 million Georgians, despite it being Friday and despite it being late in the evening. On that note, Mr. Secretary, will you read for us the caption of House Bill 345 as we continue to work?
House Bill 345 by Representatives Cooper of the 43rd and others. The bill will be titled an Act to amend Article 1 of Chapter 1 of Title 42 of the OCGA relating to inmate policies so as to provide for prohibited practices relating to a pregnant female inmate or a female inmate who's in the immediate postpartum period and for other purposes. Mr. President, Senate Committee on Health and Human Services offers the following substitute to House Bill 345. A bill will be titled an Act to amend Article 1 of Chapter 1 of Title 42 of the OCGA relating to inmate policies so to provide for prohibited practices relating to a pregnant female inmate or a female inmate who is in the immediate postpartum period and for other purposes. Amendment 1 by Senator Heath of the 31st and others offers the following amendment. Amend the substitute to House Bill 345 by replacing line 6 with the following. Annual reporting of certain information to require the Commissioner of Corrections to report certain information regarding United States Immigration and Customs Enforcement detainers, offenses, and home countries of persons who are confined under the authority of the Department of Corrections and for other purposes. Amendment 2 by Senator Harper of the 7th and others offers the following amendment. Amend the Senate Committee substitute to House Bill 345 by striking lines 57 through 86. Mr. President, that concludes the order.
Chair recognizes the senator from the 45th to speak to House Bill 345.
Thank you very much, Mr. President. And congratulations to the senator from the 48th passing your bill. I bring before you a bill that has been worked on, House Bill 345, by the chairman of the Health and Human Services. It's also an issue that has been around the Capitol for a couple of years now, and in particular, the Women's Caucus, which is bipartisan in the House and the Senate, has been concerned about this particular issue. So it's a very good thing that it is finally coming forward. And the purpose of the bill is to amend Title 42 that disallows what is called, in common terms, as shackling of female inmates when they're pregnant. And they don't have to be an inmate in particular, but being taken up for custody. It prohibits custodians from requiring certain pregnant women to squat or cough during strip searches. It prohibits vaginal examinations of pregnant women in custody unless conducted by a licensed health care professional. It prohibits custodians from using certain restraints on women in certain circumstances. It provides for pregnant women under sentence to a state prison be transferred expeditiously. And it also requires various entities to provide annual reports. In the Senate Health Committee, we did make a change to specifically include juveniles, which would be anyone less than 18 years old. In the original version, they were not incorporated into the bill. So I believe there is an amendment that has been submitted. There was some controversy, and there continues to be controversy because of the reporting requirements. It's not that any particular correctional facility does not want to do this. It's the bureaucracy associated with the reporting requirements, and I believe that's what that amendment addresses. I'll be glad to answer any questions on this particular bill.
You have no questions, Senator.
Thank you. I yield the will, and I'll be glad to address the amendment at the appropriate time.
Chair recognizes the senator from the 31st to speak to amendment number 1. Well, Senator, Chair recognizes the senator. For what purpose the senator from the 6th rise?
Point of order.
State your point of order.
And I'm not sure if this is the appropriate time, but when I'm ruling on germaneness with respect to Amendment 1.
We'll allow the author to present it. Thank you. Chair recognizes the senator from the 31st to present the amendment.
Thank you, Mr. President. A very simple amendment. This would just require quarterly reports on the department's website relative to the number of non-citizen inmates and their in their custody and their immigration status. Be glad to answer any questions.
You have no questions.
Thank you.
Chair recognizes the senator from the 7th to present amendment number 2.
Thank you, Mr. President. I believe the lady from the 45th briefly spoke to this amendment, but it simply gets rid of the reporting requirement and the additional paperwork and bureaucracy that would cause both on our Department of Corrections and our local sheriff's departments across the state. It just addresses that concern, does not affect the underlying measure of the bill. And if there are no questions, Mr. President, I yield the will.
Chair recognizes the senator from the 48th for a question.
Thank you, Mr. President. Does the chairman yield?
I'll yield.
Isn't it true that we should hold our government accountable for this type of information? And we have reporting requirements on several other bills that we've passed.
I would agree that we should hold government accountable, and I believe that's the purpose of this General Assembly and a lot of what the purposes of our committees are for. And there's nothing that would prohibit the Health and Human Services Committee, the Public Safety Committee, or any other committee in this General Assembly to request this information from any of these agencies or departments or from our local law enforcement. There's nothing that would prohibit that information from being requested, and I believe that we could still receive that information. This would just do away with it being affected in the code. And I think we can still get this information if we so desire.
Does the chairman further yield?
I'll yield.
Isn't it true, though, you're talking about we can request this information, that would require numerous different entities to do open records requests, and that would actually be a further bureaucracy that would be unworkable, and thus it would make more sense to just have a reporting requirement.
So I would disagree to a point. A request from a committee of this General Assembly works a little differently than what you would consider a normal open records request. A request from this General Assembly could address the concerns that are laid out in this legislation, and we could receive that information, and actually could receive additional information if we so desire, further than what's required under what's being before you. I just think that this is a burdensome requirement that we're putting on our local law enforcement, our local sheriff's departments, as well as our State Department of Corrections, to provide us this information, and it's something that we can obtain in other avenues instead of requiring them to send us a report every year.
Does the chairman further yield?
I'll yield.
Isn't it true that this body also passed the abortion ban, and that this information would be totally relevant to finding out whether miscarriages, live births, stillbirths, that's all relevant to that bill that was just passed by the House today and by this body with respect to an abortion ban?
I'll leave it to the gentle lady's understanding of that and respect your opinion in regards to that issue.
Thank you, sir. I appreciate it.
Mr. President, I yield the will.
Senator has yielded the well. Please stand at ease for a moment while we take up the germaneness for amendment number 1. I'd like to recognize the senator from the 45th to speak to amendment number 2. Amendment number 2.
Thank you very much, Mr. President. I appreciate the non-germaneness on amendment number 1. I agree with that. And on amendment number 2, it strikes that last section. And we did hear from the Sheriff's Association and even my own sheriff in Gwinnett County had reservations about that, and it was because of the volume of people that he deals with and the requirements of the paperwork and the bureaucracy and the reporting. And we also heard from smaller counties that also have concerns with having to do reporting requirements and the manpower that is needed to be able to do that. My suggestion would be to implement the basis of the bill and to deter that treatment of possible treatment of those women and to implement that across the state to see how that goes. If we need to do the reporting requirements next year, to come back and implement those next year. That would be my suggestion. I'll be glad to answer any questions about amendment number 2.
Chair recognizes the senator from the 48th for a question.
Thank you, Mr. President. Does the chairman yield?
Yes.
Isn't it true, Madam Chairwoman, that this data reporting is directly relevant to House Bill 481 that was passed, which is the anti-abortion bill, because it covers live births, stillbirths, it appears to cover miscarriages, and this is all data that is directly relevant to that bill if we're actually following that bill.
Well, I think the reporting requirements are more targeted towards understanding our maternal and infant mortality rates. And that's what I would be more interested in. But I am concerned when you have the sheriffs, in particular, across the state that have reservations. I hold them in great accountability standards, that they're taking care of our constituents, and when they say they have concerns, I listen. And I share those same concerns. But I do know that the underlying bill is very, very important, and I would rather see the underlying bill pass, because we've been working on this for a number of years, and let this data reporting be addressed in the next session, if it is a problem.
Does the chairwoman further yield?
Yes.
I agree with you that I would like to see this bill pass. However, I would also like to see this accountability pass, because we do have the worst maternal and infant mortality rates in the country. And therefore, it would seem that this reporting would be critical to helping us dig out of that hole. And I presume when you say you worked on it for several years, that that was taken into account when you put this bill together. Wouldn't that be fair to say?
Well, actually, the chairman in the House has worked on this bill much more than I have. But I do know from attending the Women's Caucus meetings that this has been an issue. I did meet a particular woman who came and testified. She was a former nurse, and she actually had this happen to her. She had her own personal experience. And that's why I think it's so important that the bill get passed. But the data, if the sheriffs are saying there's a problem, I don't believe that they would be saying that if they truly didn't believe it.
Thank you.
You have no more questions.
Thank you. I yield the well, and I ask for your favorable consideration and to pass Amendment Number 1.
The senator from the 6th has asked a question about germaneness on Amendment Number 1. The chair has examined Amendment Number 1. The fundamental purpose of the original bill is to prohibit certain practices related to pregnant female inmates. The fundamental purpose of the amendment is to mandate reporting regarding U.S. immigration and customs enforcement. Therefore, the chair finds that the amendment is not germane. The amendment is not germane. We will take up Amendment Number 2. The question is on the adoption of Amendment Number 2. For what purpose does the senator from the 45th rise?
Parliamentary inquiry.
State your inquiry.
I'm sorry, Mr. President, I misstated. I just realized it's getting late in the hour, and I misstated. I agree with Amendment Number 2.
All right, the question is on the adoption of Amendment Number 2. Is there objection to adoption of the amendment? There is objection. All those in favor of the amendment from the senator from the 7th will vote yea, opposed nay. The secretary will unlock the machine. On the adoption of the amendment, the yeas are 33, the nays are 21, and the amendment is adopted. The question is now on the adoption of the committee substitute as amended. Is there objection to adoption of the committee substitute as amended? Chair hears none. The committee substitute is adopted as amended. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. The main question is ordered. Shall this bill now pass by substitute? The question is on the passage of the bill by substitute. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 52, the nays are 1. This bill having received the requisite constitutional majority is therefore passed by substitute. We are now going to take up some special actions. Chair recognizes the senator from the 18th for a motion.
Thank you, Mr. President. I move that the Senate agree to the House substitute to SB 122.
Mr. Secretary, please read the caption.
Senate Bill 122 by Senators Kennedy of the 18th and others, a bill we title enactment Article 22, Chapter 1 of Title 10 of the OCGA, relating to motor vehicle franchise practices so as to provide for protection of certain consumer data in motor vehicle sales or lease transactions and for other purposes. Mr. President, the House offers the following substitute: Senate Bill 122, a bill we title enactment Article 22 of Chapter 1 of Title 10 of the OCGA, relating to motor vehicle franchise practices as a provide for protection of certain consumer data or motor vehicle sales or lease transactions for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 18th to speak to his motion.
Thank you, Mr. President. Colleagues, you remember the bill that we brought for the Georgia Automobile Dealers Association that I described for you was a negotiated resolution between the main two shareholders or stakeholders, the Georgia Automobile Dealers and the manufacturers. Well, that negotiation process continued, and there were a few more revisions made on the House side. There were really nothing of substance, but just in case you're wondering, on line 41, minor things were changed. For example, where the wording was a third party was changed to distributor. A few references where there was a reference to motor dealer was changed just to dealer, and a few other very minor deletions. Nothing was substantive, and again, I'm pleased to report to you that the shareholders or the stakeholders, the dealers and the manufacturers are fine with this bill and ask that it be adopted, and I do too.
You have no questions.
Thank you. Thank you for your vote.
Does any other senator wish to speak to the motion? The chair hears none. Senator from the 18th has moved that the Senate agree to the House substitute to Senate Bill 122. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the motion, the yeas are 54, the nays are 0, and the Senate has agreed to the House substitute to Senate Bill 122. Chair recognizes the senator from the 9th for a motion.
Thank you, Mr. President. I move that the Senate agree to the House substitute to SB 214 as amended by the Senate.
Mr. Secretary, please read the caption.
Senate Bill 214 by Senator Martin of the 9th and others, a bill will be titled and enacted in Chapter 10 of Title 43 of the OCGA relating to barbers and cosmetologists so as to change the number of apprenticeship hours required for cosmetologists, hair designers, estheticians, nail technicians, master barbers, and barbers too, and for other purposes. Mr. President, the House offers the following substitute to Senate Bill 214, a bill will be titled and enacted in Titles 31 and 43 of the OCGA relating to health and professions and businesses, respectively, so as to provide for and modify the regulation of certain professions, provide for the regulation permittance, and for other purposes. Amendment 1 by Senator Martin of the 9th offers the following amendment. Amend the House substitute to Senate Bill 214 by inserting change the number of apprenticeship hours and 2 between signs 2 and remove on line 7 and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 9th to speak to his motion.
Thank you, Mr. President. I bring back SB 214. As you remember, we had a good conversation with regard to this. This deals with apprenticeships, with our cosmetology and other services similar to that, barbers, nails, and with the famous, there was a famous question asked. Now, we did, over in the House, we had a lot of conversations with the subcommittee process. There's a couple other things that have been added on here. Came back to the House dealing with body artists for microblading. This is where, if you're familiar with this, people who maybe have in chemotherapy or radiation have lost their eyebrows. These folks go in and they will actually tattoo eyebrows back on for these people. So we added some things in there to make that better. For that piece, that was a bill that just didn't quite make it over. I agreed to carry that on here. Sections 3 and 4 deal with electrical contractors, and that was added at the last minute in committee. What my amendment does, and they also stripped most of my bill. So what I decided to do in the amendment is adding back the apprenticeship hours. However, there were some concerns by the senator from the 38th. Instead of cutting for our cosmetologists, instead of cutting those hours in half, we instead just reduced them by 500. But in addition, we also made sure that at least 300 of those 2,500 hours will be dedicated to the study of theory. So making sure that these people know what they're doing when they're working on you there. So we put the rest of that bill back in here. Also, estheticians, we did not cut it fully as well, and we added some theory hours in there because of the services they provide as well to make sure they fully understand, have a full understanding of what they're doing. So basically what we did is we added the apprenticeship language back in with some changes that had been agreed to in the House, and we are deleting sections 3 and 4 that deal with the electrical contractors that we have a little bit of a problem with over here. They didn't quite make it over in the House, and I'll yield for any questions.
Chair recognizes the senator from the 17th for a question.
Senator, yield.
Of course I'll yield.
Senator, isn't it true you've gotten a haircut since last time you presented this bill?
Yes, sir, it is true. I have gotten a haircut. Got every one of them cut, Senator.
Do you further yield?
I do not.
I was just going to tell you, I think you look very nice tonight.
Thank you.
Chair recognizes the senator from the 41st, Minority Leader, for a question.
Senator Yield.
I will.
You mentioned cosmetologists, but this amendment will cut hours for barber shops, is that correct?
It does cut hours for barbershops. They don't deal with the chemicals and that sort of thing that cosmetologists deal with. That was all stuff that we left in the bill as those were not issues that were raised in the committee process on the other side with the House. So we left those as they were. Every conversation we had was around cosmetology and aesthetists.
Senator, further yield.
I will.
Your original bill included barbers, cosmetologists, hair design, and others, right?
Nail technicians, yes, sir.
And now you are not addressing nail technician?
We do. We left those as they were when they passed this body.
Okay. And is it further, if the Senator will yield?
I will.
I had heard that the board, Barber Board and some others opposed this bill or were not in support. Do you have any of these boards or related boards with a letter of endorsement or committed their support to you?
I do not have that. I know there were some concerns, and we tried to, and that was the purpose of making sure that we only decreased the hours by 500. The purpose of this bill is to make sure that we are encouraging people to use the apprenticeship route, because when you use the apprenticeship route, you can make sure that you are actually making money, earning a living while you're learning the profession. So we did not cut it in half like we originally proposed. We brought that all the way up to 2,500 hours, and then we made sure that we added the theory study as well in there that would have to take place in a school situation. So they would still have to get those hours in a school.
Senator, for further yield, on some of the areas like line 78, there is a reference of 3,000 credit hours reduced to 1,500 credit hours. You know, on 91, 2280 credit hours to 1140. Those are cut in half, correct?
We did, yeah, because that's the way they left. That's dealing with barbers, nail technicians.
Is it not true states from Alabama to California are at 3,000, that many states are at 3,000, and you're cutting this without any recommendation from the boards and with opposition from many people in these professions?
You may have more knowledge of that than I would, Senator, Mr. Leader, but what I would say, again, they still have to pass the test of competency, and they have to pass a theory test as well. So if they can't show that they're capable of doing the job via the testing that we do, then they cannot get their license. And I will add one more thing that was added in the House, and I left this out, and I apologize. There was a section in here that was recommended by the Secretary of State that many of these apprentices be required to take their test within the first 12 months, because oftentimes they have to go back and check and make sure they're learning, touching on things that they need to know. So we did that so that they can take that early on in their apprenticeship, and they'll be able to find out what things they need to work on.
Would you yield for another question?
I will.
Are you surprised that my light to come speak in the well is not lighting up when I press it repeatedly?
I have nothing to do with that, whether it is or whether it's not, Senator.
Well, hopefully the President will recognize that in spirit my light is lit.
Yeah.
It's not working. Chair recognizes the senator from the 45th for a question.
Mr. Chairman, would you yield?
I would gladly yield.
I think I got a little bit of what you said. I just wanted to make sure you're not doing anything to the code section with microblading or with laser hair removal or any of these ancillary cosmetic procedures?
The bill came back with some changes dealing with microblading in the tattoo artist statute. So, it's not even called tattoo, it's now called body art and body artists. So the bill came back from the House with those changes embedded in it already. My amendment does not touch that. However, it is included in this bill as it came back from the House.
Could you tell us what those changes are?
It changes. We add a thing in there that talks about what body art is, what a body artist is. We define those. We define body art studio, which these are to strengthen the code. There's a couple, I believe in 31-40-2 that we amend that code to reflect those changes. 3140-3. Again, I think we are doing the same thing. We are recognizing those changes in definitions. In lines 62 through 65, we make it very clear that the department may deny, suspend, or revoke a body artist permit for a violation of the chapter or the rules and regulations promulgated. So we're strengthening the enforcement mechanisms under this code. 3140, again, we go to body art. We're lining that up. On line 86, we add that there's another requirement under this, that they must show a competence and specialized knowledge of body artists. So again, we're strengthening the code there. Again, as you move further down, we're lining up things to make sure that body artists rather than tattoo studios is reflected in the code. Lines 98 through 103, section 31-40-8. We make sure that every body art studio or tattoo salon, whatever you want to call it, they have to conspicuously display in a prominent place, easily seen by patrons, a printed sign that warns that any body art on the face, neck, forearm, hand, or lower leg of any individual may automatically disqualify such individual from military service. And it goes on a little further, but that's what it says. It gives a size requirement of that as well. And those are the changes.
Could you just, what does it do to microblading?
I skipped over that part, excuse me. That's on lines 28 through 32. We clarify the definition that says they have to use a handheld or machine-powered tool made of needles, known as a microblade. So we clarify that definition of what a microblade is.
Would you further yield one last question?
I will.
What started out as a barber bill sounds to me like it's a massive rewrite of cosmetology and ancillary procedures. Didn't it start out as a barber bill?
It dealt with aestheticists, I can't say that word, but you know what I mean. Cosmetologists, nail technicians. I mean, it began with all of those. So I don't know that I would agree. I think the only thing that we've added to it would be the body art and microblading section.
Would you further yield?
I will.
I guess it goes back to the minority leader's question. Did the industry come forward? I mean, what is the need for this? Did the industry come forward and say, we want to change all these code sections? Or where did this originate from? I just don't see the need.
This came from the idea that we should continue to work with our small businesses and make sure that we are incentivizing the apprenticeship process that works. And it works in this situation. We really tried to work in every which way to make sure that we met the concerns of the cosmetology board, and those that came to speak with us in the committee process.
Does the senator continue to yield?
I'll yield one more question.
Chair recognizes the senator from the 15th for a question.
Thank you, Mr. President. Senator Yield.
I will.
Senator, I'm trying to understand the length of your amendment. Are you concerned that if it's over half of the original, that it would have the effect of killing the bill?
Thank you, Mr. Chairman. I was concerned, but because this is a special order, those requirements do not apply.
Right.
No.
You have no more questions.
Thank you, Mr. President.
Chair recognizes the senator from the 41st and proud to report that the electricians fixed your problem and the wires now work. Your button's lit up.
Proud to report, Mr. President, that the electricians have a 4,000-hour apprenticeship program, as do the laborers who dig ditches, and many other good things. But I want to raise a concern to each and every one of you. When we are addressing issues like this, we really should have recommendations from the professional board that the governor appoints to manage their affairs. We do not have this here. In fact, when the author of the bill presented in committee, we asked if he had talked to them. He said no. In the House, he said the think tank maybe came up with this idea. I will say to you that some former members of the board testified, and some active members of the board testified and said it was a bad idea, it was wrong. John Seegers, who owns a large hair salon in my district and who has been on the board before, went over at length to me how, when you are a barber, the public safety is critical. The public safety is the most important thing. People cutting your hair, your physical contact with you, their preparation and their safe and healthy conduct is critical to the public. We should not be doing something like this on the fly. If experts say it's not a good idea, the House stopped it for a reason. I would say to you that states, some states have more. Louisiana has 4,000 hours. Alabama 3, 32 in California, Delaware 3. So, this is something that we're cutting down on the fly to what I think is an unsafe level. Remember, 1,500 1,500 hours sounds like a lot. But when you're talking about apprenticeship, as I mentioned earlier, the trades and construction are 4,000 or more. When you're talking 1,500 hours, you're talking about less than a year. You know, you're talking about less than a year of on-the-job apprenticeship training. And if it's something that, you know, people say, well, you make more money once you're a journeyman, that may be true, but as your apprentice, if you're good, they can pay you more money. So I just think you should be cautious on this bill. I think the question of the senator from the 45th were very enlightening, and I just would urge you to vote no on this amendment to the underlying bill. You know, in committee, I will say, in the Senate committee when we passed this, and I voted for it, we did not have testimony from any of the boards represented in cutting their apprenticeship hours. I think that is not a proper action for us when we think there are concerns. I'll yield for questions.
Chair recognizes the senator from the 38th for a question.
Thank you, Mr. President. Will the senator yield?
I yield.
Is it not true, is it not true that I know a person who actually sits on the board of cosmetology at this time? And I did speak with her, and she was not in agreement of this. I've also, is it not true, spoke with a couple of owners of schools and have apprenticeship, and they were not in agreement with this.
Senator from the 38th knows of what she speaks. There are more than 20 years here in the Senate, and her experience with many of these professional boards, I think, affords us some insight into some people who serve on the board that do not support this bill.
You continue to yield?
I yield.
Chair recognizes the senator from the 9th for a question.
Thank you, Mr. President. Will you yield?
I yield.
Isn't it true that I know you mentioned a couple states that do have more than 3,200 hours, that many states also only require 2,000 hours?
There are a few states that require 2,000 hours, but there are many states, there are about 18 states that don't have any apprenticeship for the standards. But I will put this to you, that these schools, these programs are in place. And with bringing this to us without it being vetted by the board, talked to by the board, are going to put all of these schools and programs into a big lurch dropping this down, number one. Number two, I feel personally that it will endanger the public, or certainly it's not a course of actions we should take without hearing from the industry that there are solid reasons. So I, much like the Republican chair of the committee that did not let this out, think that we should hold it up today.
Will you further yield?
I yield.
Isn't it true that this bill would actually get people to work and give them more of an incentive to get to work in a safe way, because they also have the theory training and 2,500 hours, which adding that 2,500 hours with those 300 class hours, which they may not be able to afford otherwise, but this will actually give them on-the-job training in addition with that theory training that's so important to make sure that our public is kept safe.
No, that is not true. You're actually, when you are an apprentice, you are working on the job under the supervision of trained, experienced journeymen. So these people as apprentices, even though it's 3,000 hours versus 15, those extra 1,500, they are working on the job. That is the entire concept of apprenticeship, to be under journeymen, under people who know what they're doing, but working on the job and actually earning money as apprentice. So that is not correct.
Do you continue to yield?
I will.
Chair recognizes the senator from the 50th for a question.
Mr. Leader, will you yield for a question?
I will.
It's late in the day, and I'm a little bit slower processing some of this information that you've given us. But I think you mentioned some states, maybe some adjoining states, some states on the West Coast that require even more hours than we do. Is that correct?
Including some states in the Southeast, correct.
Would you yield for another question?
I will.
Is it your belief that the reason they require those hours is it just takes a little bit longer to train those people?
I understand where the senator who's proud of Georgia and the lightning speed of our intelligence and faculties, but I will say this, that for a number of years professionals thought 3,000 hours were appropriate, even for our highly intelligent and capable people of Georgia. I think that's probably where we need to stay. Thank you, Senator.
You have no more questions.
Thank you.
Does any other senator wish to speak to the motion? The chair hears none. The senator from the 9th has moved that the Senate agree to House substitute to Senate Bill 214 as amended by the Senate. All those in favor, vote yea. Opposed, nay. The secretary will unlock the machine. On the motion that the Senate agree to the House substitute to Senate Bill 214 as amended by the Senate has failed. Chair recognizes the senator from the 53rd for a motion.
Praise God. Are you going to move Sonny Dye? Are you moving Sonny Dye? Sonny Dye, Sonny Dye. Action. Sonny Dye. Would you leave?
Mr. President, I move that the Senate adhere to its substitute to House Bill 264, and that a conference committee be appointed of outstanding senators to combat the misguided conferees of the lower chamber.
Will the secretary read the caption?
House Bill 264 by Representatives Werkheiser, the 157th, and others. A bill be titled enactment Article 4 of Chapter 5 of Title 21 of the OCGA relating to public officials' conduct and lobbyist disclosure so as to provide that any natural person is undertaking to promote and for other purposes. That concludes the order.
The chair recognizes our esteemed Rules Chairman from the 53rd District to speak to the motion.
Mr. President, this is the bill dealing with emergency management with ambulance service and so forth, and we want to re-engage with the House and put measures of openness and clarity into the bill, plus some other things that we need to do with ambulance service. So I appreciate your help with this. Have a nice day.
Does any other senator want to speak to the motion? The chair hears none. Senator from the 53rd has moved that the Senate adhere to its substitute to the amendment to House Bill 264 and that a conference committee be adopted. Is there objection? Chair hears none, and the chair selects the senator from the 53rd, the 28th, and the 9th as our Senate's conferees. Chair recognizes the senator from the 28th for a motion.
Mr. President, I move that the Senate adhere to its substitute to HB 324 and that a conference committee be appointed so that we can fight the treachery of the House.
Mr. Secretary, will you please read the caption?
House Bill 324 by Representatives Gravely, the 67th, and others. A bill be titled enactment Chapter 12 of Title 16 of the OCGA relating to offenses against public health and morals so as to provide for the production, manufacturing, and dispensing of low THC oil in the state and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 28th to speak to his motion.
Mr. President, they've done it again. And I'm not going to stand for it, and you shouldn't either. I demand that we have the best of the best to go fight them. Thank you.
You have no questions. Does any other senator wish to speak to the motion? The chair hears none. Senator from the 28th has moved that the Senate adhere to its substitute to House Bill 324 and that a conference committee be appointed. Is there objection? The chair hears none and appoints the senators from the 28th, the 46th, and the 17th as the Senate's conferees. Chair recognizes the senator from the 16th for a motion.
Mr. President, I move that the Senate agree to the House substitute for SB 132.
Mr. Secretary, will you please read the caption?
Senate Bill 132 by Senators Harbin of the 16th and others, a bill be titled enactment Title 33 of the OCGA relating to insurance so as to provide for modernization and updates and for other purposes. Mr. President, the House offers the following substitute to Senate Bill 132. Bill be titled enactment Title 33 of the OCGA relating to insurance so as to provide for modernization and updates and for other purposes. Mr. President, that concludes the order.
Chair recognizes the senator from the 16th to speak to his motion.
Thank you, Mr. President. This is our SB 132, which is the first part of two parts of the rewrite of the insurance code and the modernization of the insurance code, and it's modernizing it with language, and that's simply what it does. It's a rewrite of the insurance code that we currently have.
You have no questions. Does any other senator wish to speak to the motion? Chair hears none. The senator from the 16th has moved that the Senate agree to the House substitute to Senate Bill 132. All those in favor vote yea. Opposed, nay. The Secretary will unlock the machine. On the motion, the yeas are 48, the nays are 0, and the Senate has agreed to the House substitute to Senate Bill 132. Chair once again recognizes the senator from the 16th for a motion.
Mr. President, I move that the Senate agree to the House substitute for SB 133.
Mr. Secretary, will you please read the caption?
Senate Bill 133 by Senators Harbin of the 16th and others. The bill will be titled enactment Title 33 of the OCGA relating to insurance so as to provide for modernization and updates and for other purposes. Mr. President, the House offers the following substitute to Senate Bill 133. The bill will be titled enactment Title 33 of the OCGA relating to insurance so as to provide for modernization and updates and for other purposes. That concludes the order.
Chair recognizes the senator from the 16th to speak to his motion.
Thank you, Mr. President. This is the second part of the first, modernizing our insurance code to modern language, and that's simply what it is.
You have no questions. Any other senator wish to speak to the motion? Chair hears none. Senator from the 16th has moved that the Senate agree to the House substitute to Senate Bill 133. All those in favor vote yea. Opposed, nay. The Secretary will unlock the machine. On the motion, the yeas are 51, the nays are 0, and the Senate has agreed to the House substitute to Senate Bill 133. Chair recognizes the senator from the 31st for a motion.
Thank you, Mr. President. I move that the Senate agree to the House substitute to Senate Bill 213.
Mr. Secretary, can you please read the caption?
Senate Bill 213 by Senators Heath of the 31st and others. A bill will be titled and act amend Article 2 of Chapter 5, Title 21 of the OCGA relating to campaign contributions so as to revise the content of and certain reporting times for certain campaign disclosure reports and for other purposes. Mr. President, the House offers the following substitute. The Senate Bill 213 bill will be titled and act amend Article 2 of Chapter 5 of Title 21 of the OCGA relating to campaign contributions so as to revise the content of and certain reporting times for certain campaign disclosure reports and for other purposes. That concludes the order.
Chair recognizes the senator from the 31st to speak to the motion.
Thank you, Mr. President. Members of the Senate, Senate Bill 213 was placed on your desk a little bit later today. This is a bill we passed 51 to nothing on March the 7th. This is dealing with campaign contribution dates. It does a few things. We had a little problem in it when it left here, and the House Minority Leader, Chairman of Judiciary helped to get all that straightened out. But clarifies when you reset your contributions and expenditures, minimizes the number of 2 business days that are reports that are required. If you notice on line 76 and 77, it moves the March 31 date to April the 30th to get the disclosure a little bit closer to the election. Be glad to answer any questions if there are any.
You have a question. Chair recognizes the senator from the 56th for a question.
Thank you, Mr. President. Senator, will you yield?
Yes, sir.
It appears we do not have a copy of this bill in either of our folders.
This bill passed the House today. It was handed out, I believe it was a little bit before lunchtime. It was placed on your desk. It very well could have gotten misplaced.
Mr. President, I would ask that we check on that before going forward, parliamentary inquiry.
It would be a pink copy. It would not be in your book. It would be on your desk. Yep.
Senator, well, you've got a question while
Okay.
we're checking with the secretary. Chair recognizes the senator from the 27th for a question.
Thank you, Mr. President. Chairman, do you yield?
Yes, sir.
Can you clarify? I know there was some question after this was passed out of this body relative to the period from January until when we start session and the reporting requirements therein. Has that been changed in the House substitute?
Just ask restate the last part of that question.
Has that portion of what we passed changed on the House side?
So what we did was we clarified that the January 31 reports stay in place for us, and the 12/31 reports will we'll file a 12/31 report on non-election year. No, it's January 31 every year for us.
Thank you.
And the part that I would, I think would be beneficial for everyone to understand, so there's been questions about when you reset your contributions and expenditures, it will be, you reset them on the January 31 report.
Chair recognizes the senator from the 8th for a question.
With the senator, you.
Yes, sir.
Since I don't have a copy, and evidently some others don't have a copy, would you just run over the reporting dates that's in this legislation we're considering?
Yes, sir. In an election year, it will be January 31, April 30th, June 30th, September 30th, October 25th and December 25th.
Senator, you have no more questions.
Thank you, sir. I urge your support.
The Secretary has informed me that the measure was not passed out, but has the copies of it currently and is going to pass it out as we speak. We'll stand at ease momentarily. All right, the amendment is on each and every member's desk. Would any member like to speak to the bill? Senator from the 31st has moved that the Senate agree to the House substitute to Senate Bill 213. All those in favor vote yea, opposed nay. The Secretary will unlock the machine. On the motion, the yeas are 45, the nays are 1. The Senate has agreed to the House substitute to Senate Bill 213. Chair recognizes the Majority Leader for a motion.
Mr. President, I move that the Senate table the bills and resolutions remaining on the rules calendar and the supplemental calendar.
The Majority Leader has moved that the bills and resolutions remaining on the rules calendar and supplemental calendar be placed on the table. Is there objection? Chair hears none, and they are placed on the table. Chair recognizes the Majority Leader for an additional motion.
Mr. President, I now move that the Senate stand adjourned until 10 a.m. on Tuesday, 2 April 2019.
I want to thank each and every one of you for a great day of work today. Mr. Secretary, will you read the announcements?
Mr. President, there are no committee meetings.
Are there any members that have any announcements? The Majority Leader has moved that the Senate stand adjourned until 10 a.m. on Tuesday, April 2nd, 2019. All those in favor of the motion signify by saying aye. All opposed, no. The ayes clearly have it, and the Senate stands adjourned.